Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hello and welcome back to the Business Law, Estate Planning, and Estates Podcast with attorney Thomas LaPorte. Thomas is the founder of LaPorte Law Group, PLLC, with an office in Portsmouth, New Hampshire, as well as a location in Andover, Massachusetts. For more than 25 years, he has guided individuals, families, and business owners through estate planning, probate, and business transactions. My name is Kevin Rosenquist, and today we're talking about what every new business owner should know about getting started on the right legal footing. Thomas, welcome back.
Kevin, how are you, sir?
I'm doing great. How are you?
I'm good, thank you.
Awesome. Well, let's get right into it. When someone is first starting a business, what legal basics should they take care of early in the process?
Well, the first thing that they need to decide upon is what legal structure they're going to use. There is a sole proprietorship. There is a partnership structure with which is defined as association of two or more persons that will share profits and share losses. And then the smarter structures, as I like to refer to them, are limited liability entities. The newest of which is newest since the mid-90s is a limited liability company. Those were enacted, I think, in Nevada and Delaware in the mid-90s, and then all the other states have adopted them for smaller businesses. Mm-hmm. It is designed for smaller businesses because there's less corporate formalities, record keeping, and that sort of thing. Beyond that, you have your corporations. There are two types. One is an S corporation, again, for small businesses, and then a C corporation, which are for your larger, more mature companies. There are, within general partnerships, harking back to partnerships, one can be a limited partner, and those are generally for investors in a partnership. For instance, I had when I worked in California, there was a film that was being produced, and I represented 37 different limited investors, and they were all limited partners. That is the first choice to think about, aside from who you're doing business with and your business plan.
And what you're doing.
Exactly.
Yeah. How does one choose which is the best for them?
Well, I think the first thing that people ought to think about, besides business people, entrepreneurs should think about, besides the great idea, and there's many great ideas out there, the product, the service, how to get it to market, who your consumers are, how you're going to get the product, the service to the consumers. Is it through other third parties? The first thing to think about is, before we start thinking about third party business partners and whatnot, is the risks of being in business, the risks of facing the public, being forward facing to the public. Business is basically pushing risk back and forth across the table. Okay, you want to sell your products. People want to buy it for as least amount of money as they can, but the risk is you don't make money. Mm-hmm. What if a product or a service doesn't do what it's expected to do, or at least someone claims it doesn't? So aside from the positive business thoughts and schemes that business people think about when they first generate an idea and try to put it into action, is you got to think about the risks of dealing with the public, with third parties that you enter into contracts with, and even governmental agencies, because there are requirements to the states primarily, and to the federal government when one gets into business. There's various taxes that apply to businesses that don't apply to individuals. So evaluating risks and trying to minimize and reduce those from the get-go is paramount.
Tell me if you've heard this before between two upcoming business partners. Oh, we're fine. We get along great. We're never going to have any problems or anything like that down the road. Do you hear that often?
I've seen it quite often. I've heard it even more often. I'll give you a statistic that I heard probably 20 years ago, and I think I don't have any information that's not accurate. 85% of people that go into business with each other, they fail down the line. And a large reason for that is because they don't plan. They don't put down the expectations and agreements in writing in the beginning during the honeymoon phase, which is what you're alluding to, Kevin. The honeymoon phase, everybody has the best of intentions. Everybody's excited, whether it's two folks, two friends, three or more, because they haven't encountered any resistance or pushback or economic difficulties. The challenge is just like a marriage. It is a business marriage.
It is. You're right.
So nobody likes the word prenup, but with business, it's a little more acceptable, I think, to have a prenup, which basically is an agreement. An agreement should be set forth in writing during this honeymoon phase, because that's when people are most willing to compromise and make agreements, because again, they're both gung-ho about the business and are more likely to agree and compromise on things like what are our respective responsibilities to each other and to the company. When are we going to get paid? What expenses will be paid first? Is there a dollar limit above which both of us have to agree, either in writing or orally? I like to say, if it's not in writing, it didn't happen. Yeah. So with smaller businesses, usually there's an upset limit, say $5,000 that for expenses that are out of the ordinary, out of the day-to-day business. Those are three examples of things that should be agreed to in the beginning. And it's funny, we as Americans, even more so than in Europe, we have a psychological attachment to our signed signature on a document. Whereas if we don't, then, there's this word called confabulation. Well, this is what really happened. People remember things differently, but if you set it forth in writing, well, it's there permanently for posterity, and people tend to abide by what they've signed off on.
Mm-hmm. What are some of the biggest issues that you see in a new business as a new business moves forward when they don't have proper legal paperwork?
Lots of times there is an argument over the division of labor, who's working more than the other. So one can put into, say, LLCs. LLCs are very popular and probably the entity of choice for most smaller businesses. C corporations, which have two levels of taxation, are for more mature businesses that wish to attract outside investors. It has a veneer of maturity, if you will. But for people starting off in businesses, disputes arise over who is supposed to do what and if they did it. So I have written operating agreements and bylaws in S corporations, which are also for smaller businesses, where the responsibilities are spelled out and the hours expected are spelled out, and the checks and balances and the verifications, accountability is spelled out. It's not that hard. And again, during the honeymoon phase, if we want to make this business work together, we'll agree in the office of whomever's helping you or at the conference table to those terms. Other things that derail businesses in the beginning are not scrutinizing contracts. If you get your first deal, the devil's in the details. There's no such thing as a standard contract, a boilerplate. So just accepting and signing on the dotted line because we really want that business, you take on more risk, and oftentimes you can push back on some of these terms. You will not lose the deal. So consulting with someone who's been around business, been around the legality of business, and can tell you what risk you can take by pushing back on a contract. Doesn't need to be an extended negotiation, for instance. A good business attorney will be able to get the deal done, but also build in some protections as much as possible. So, businesses are in competition with each other. Right. And oftentimes it's a win-win, but sometimes it's not. So you got to be careful who you're dealing with and what the terms of the contract are between whomever you're dealing with. So internal problems, external problems. And then thirdly, if one doesn't understand what is required as far as filings with the government, there are different tax returns that businesses have to file. There are insurances that businesses need to have. For instance, workers' compensation, if you have an employee, mandatory. Oftentimes, most states, however, if you're a single person owner of an LC or an S Corp, and you can have those, allow for exemptions for single owner employees. But those are some of the types of items that can be challenging for new businesses. So internal, external, and then government.
Yeah, the external one is an interesting thought because you're right. You're a new business. I mean, you probably 9 times out of 10, you need customers, right? You need clients. You need business. So yeah, rushing through contracts or rushing through agreements or not really understanding maybe what the business relationship is with a client could definitely bite you in the butt later on if you're not careful. For sure, I could see that.
Right, and people are sort of afraid to lose that business, but
Yeah.
At least if you sit down with someone who has experience with it, even if it's another business person, a mentor, if the counterpart to the contract won't agree on certain things, then at least you know what the risks are.
Right.
And then you can maybe, as you go along with that relationship, you can mitigate those risks later. Perhaps you garner some traction with this company, leverage. They really like your product and they're making money off it too. Then you can modify the contract later on. But you got to know what needs to be modified.
Mm-hmm.
So.
When it comes to employment agreements, as far as like just new, you're bringing on employees, maybe you're bringing on employees pretty quickly. What do you recommend for businesses as far as agreements or handbooks or anything else that could protect them early on if they're bringing on employees in the early stages?
I absolutely think that companies, even if they're small, ought to have policies. It can be put into what's called a handbook or a manual. These days, most companies can very easily set up a website and those policies, handbook, if you will, or manuals are simply posted on there online and accessible to all of the employees. So you've got to make the employees knowledgeable of those manuals and policies, have them sign off in writing, and that they acknowledge that they are aware of where the policy is. We used to hand those to employees and then would sign off. So have them acknowledge that it's on the website and that they've read it and they understood it. But within those policies themselves, you've got to write down. First of all, become aware of the leave laws in each state, whether it's sick leave or it's parental leave, paternity leave, maternity leave. Each state has their own laws. There's a federal Family Medical Leave Act that needs to be abided by. There are federal legal holidays that need to be abided by. Some states require vacation time, some don't. So find out about those. And then for your part-timers, let them know what benefits they generally are not entitled to. Or if they're entitled to, spell it out and then spell out what they're not entitled to and define what is part-time versus full-time. Is it 32 hours a week? Is it 40 hours a week? I don't like discipline regimens, meaning, a warning, oral warning, a written warning, and then termination.
Like you're in high school?
Yeah, I don't like, because if a company doesn't follow that, we call them discipline regimens, exactly, then that could be seen as a breach of contract. So what you do is you keep it open, saying, keep it within the sole discretion of the owners, write that out, that you can be subject to discipline, including but not limited to termination within the employer's sole discretion. For instance, expectations about workplace conduct have to be put in there. The manuals ought to say a couple of things that are mandatory, in my opinion, that this does not constitute a contract, okay? Because there can be terms in there that can be used against the company if there is a dispute upon separation, usually upon firing or involuntary separation. And secondly, The National Labor Relations Act, which protects protected activity, concerted activity within the workplace. People can talk about unionizing even if it's on work time. That must be put into any sort of policy now. That's been about since, I forget the name of the case, but it was 2022 that the National Labor Relations Board required that to be in every such policy or manual that you're talking about, Kevin.
Oh, so what do you think are the most common legal details that tend to get overlooked by new business owners within the first year in operation?
I think trying to think of the most common, but they're various and sundry. But one should go to the state's Department of Labor, or say in Massachusetts it's the Attorney General's Fair Labor Division. In New Hampshire, it's the Department of Labor, and they will usually publish, and the Federal Equal Opportunity Commission will publish a recommended sexual harassment policy. Got to include that in your manuals, policies, or your handbook, in addition to what I've previously said. There's got to be a written out procedure if someone complains about harassment, whether it's oral, based upon gender, sexual orientation, race, age. There's got to be a reporting mechanism. There's got to be provisions that say that we will do the best we can to keep the accuser's identity confidential. However, the accuser must be afforded rights too. So there's an interview process to both, and that the accused gets the opportunity to know who is accusing him or her of what. And then there's got to be a decision-making process put in place. So I see a lot of claims come referred to me based upon alleged harassment. A lot of it is non-meritorious, but some of it isn't. It does exist, particularly ageism, in my opinion.
Yeah.
Of course, I'm 59, so
you're biased.
maybe more sensitive to that. But those that gets overlooked quite a bit. And one other thing is, I think that new businesses must pay someone, shop around to handle your payroll if you have employees. If you are a dime late, many states, including Massachusetts, and I did this, I was on the Reuter case in 2022, there are mandatory treble damages plus attorney's fees that can be levied against you, and those fees can be far more than what you didn't pay the person on time. So I guess wages and then the harassment policies are something that new businesses tend to overlook.
Yeah, I could see that. Well,
regarding employees, yeah.
If there's one takeaway, it's plan. Just plan for all these things, talk to an attorney, make sure that you're set up for success from the start, and you can avoid all this. All right, well, that's it for today's episode of the Business Law, Estate Planning, and Estates Podcast. If you're launching a new business and want to make sure you're set up for success, visit LaPorteLawGroup.net to learn more about how Thomas can help you. And be sure to subscribe to our channel and leave us a review. We got lots more great information coming your way. Thomas, it's always great chatting with you about stuff. Thanks so much for being here. Sure. And don't mean to scare you. It can all be good. Just keep our eyes wide open when we get into it. Make sure you plan, right? That's right, sir.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.